Good morning. This is your Kelso Report for Thursday, November 29th. I'm your host, Clark Kelso. Good to be back with you. We begin today with a U.S. Supreme Court reminder about the enforceability of arbitration clauses. And then we turn to the evidence necessary to support a lost profits award for a new business. And we close with a question about appellate process in state court appeals from post-conviction judgments. Now we begin with arbitration, though. As I have often pointed out, the United States Supreme Court has been engaged in a decade-long battle with California state courts over the strong federal policy favoring the enforcement of arbitration clauses. Our state courts keep looking for ways around that federal policy, and the Supreme Court has repeatedly stepped in to remind our courts that arbitration is a favored approach to dispute resolution. This battle has frequently involved California state court decisions, but the problem is certainly not limited to California. In Nitrolift Technologies v. Howard, the United States Supreme Court delivered a strong, unanimous per curiam message to the Oklahoma Supreme Court. As the court noted in its opening paragraph, quote, "It is a matter of great importance that state Supreme Courts adhere to a correct interpretation of the Federal Arbitration Act. Here, the Oklahoma Supreme Court failed to do so," close quote. The case itself was pretty easy. The Oklahoma court had declared that non-competition clauses in two employment contracts were null and void, even though the contracts contained arbitration clauses that, under ordinary principles of arbitration, should have encompassed the decision of whether to enforce the non-competition agreements. But instead of letting the arbitrators decide that question, the Oklahoma Supreme Court essentially tried to take that merits issue away from the arbitrators. As the United States Supreme Court noted, that, quote, "ignores a basic tenet of the Federal Arbitration Act's substantive arbitration law," close quote. So the Supreme Court sent the case back to Oklahoma, where it could properly be referred to arbitration. Next we have a remedies question from the California Supreme Court. One of the recurring problems in the law of remedies is that new businesses often have trouble establishing damages in the form of lost profits they allegedly have suffered at the hands of the defendant. As a practical matter, many new businesses never turn much of a profit, and the defendant's wrongful conduct may have been only one factor of many leading to reduced profits. Now, the old rule in many states was simply that a new business could not recover lost profits because such damages were speculative as a matter of law. But that rule was overbroad and essentially made it open season on new businesses. But courts still struggle with the evidentiary problems involved in proving lost profits for a new business. In Sargon Enterprises v. University of Southern California, the California Supreme Court gave the trial judge gatekeeper powers in considering whether to admit expert testimony regarding future profitability of a new business. The case involved a small dental implant company that had net profits of $100,000 in 1998. It sued the University of Southern California for breach of a contract for the university to clinically test a new implant the company had patented. The company sought damages for lost profits beginning in 1998, ranging from $200 million to over $1 billion. It claimed that, but for the university's breach of the contract, the company would have become a worldwide leader in the dental implant industry and made many millions of dollars a year in profit. Following an evidentiary hearing, the trial court excluded as speculative the proffered testimony of an expert on the lost profits. The Supreme Court affirmed. It concluded that the trial court has the duty to act as a gatekeeper to exclude speculative expert testimony, and that the court acted properly in this case to exclude speculative testimony that the company would have become extraordinarily successful had the university completed the clinical testing. The message here is simple. Courts do not exist to make speculative dreams come true. Finally, we have a question involving the appellate process. In California state courts, when a criminal defendant insists on an appeal, even though his or her counsel can find no non-frivolous issues to argue on appeal, counsel submits a brief to the Court of Appeal that simply states the case and the facts, and requests the Court of Appeal to conduct its own independent review of the trial record to determine whether there is reversible error. This is known as Wendy review, named after a case, of course, People v. Wendy. And in some courts of appeal, as much as 15 to 20% of the criminal appeals are Wendy appeals. Now, I have previously criticized this rule as constitutionally unnecessary and a waste of precious judicial resources. But the court in California continues to do this in criminal appeals. Well, in People v. Serrano, the 6th District refused to extend Wendy to an appeal from post-judgment proceedings, noting that the defendant already had completed his first appeal of right, and that Wendy applied only to that first appeal of right. There's no constitutional right to a post-conviction appeal. Since the appellate brief that was filed in the case contained no arguments for reversal, simply stated the facts of the case, the Court of Appeal dismissed the appeal as abandoned. And that's it for today's Kelso Report. Have a great day in the law.